Mr. Bennett. I've been on this bench almost 25 years, and never have I ever been insulted in the fashion you just insulted this court. No, my turn. The very first case, when you say the first case I called today was upon receiving a notification about something that I had considered in a bond, was notified that that had been located, this court, to the defendant's benefit, set that hearing without notice to any side. I set the hearing. So to be fair to all of the parties, I receive motions all the time regarding bond. And this court just seeks to be fair, to have a hearing. Now, having said that, so maybe you can put that in a little perspective. I heard you that you said you just got the discovery, can't go through it. Well, I'm going to give you about another 18 hours to go through it, because I'm adjourning this hearing for two reasons. To allow you to go through the discovery, to give me a cogent argument as to why I should not grant what the people want. And secondly, because you have raised the ire of this court. I am not going to punish your client by what was one of the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. I will not, by any means, punish him for that. I do not make my decisions out of anger. I'm adjourning this to tomorrow, May 10th, noon. All the parties are ordered to be here. That is all. That is all. Noon tomorrow. All right. Court does call the case, People of the State of Michigan versus James Whitley.
Your Honor, for the record, my name is Jeffrey Bennett. Mr. Whitley, standing to the right. Sir, please state your name.
James Dennis Whitley.
This is a continuation of the hearing. Is there anything additional from the people?
Nothing additional from the people.
Anything additional from the defense?
Nothing. Yes, Your Honor. One thing additional is that if the court finds that money bail is necessary, I believe that based on this case, an appropriate bail would be something like a $10,000. The current bond conditions regarding specifically a GPS tether with the exclusion zone and the drug and alcohol testing, I think, address what the primary concerns are in the report. He was intoxicated, and of course, he should not be drunk here. But the reason I think primarily that the $150,000 insurance bond is excessive is he has no history of any violence whatsoever. In fact,
well, can I just stop you there, because I have some concerns about the representations of what happened that were made to the magistrate at the time, and some of them made to me yesterday. I went back and listened to the arraignment, and my understanding is that the alleged victim in this case contacted the defendant to pick her up from Chelsea bowling lanes or something along those lines.
he went to Chelsea lanes to make sure she got home safe, because she was intoxicated.
Right. And then after that is when this ensued. I'm having difficulty, well, let's put it this way. According to what I have, he shouldn't have been driving. That's number
Well,
one.
he wasn't tested the allegation is that he was intoxicated. I don't believe he agrees with that characterization.
Mr. Bennett, do you know what you said at that hearing regarding intoxication? Well, first of all, I don't think there are two issues there. One, he wasn't supposed, my understanding is his license is revoked with restrictions. And that his activities in going there that night would not have been within his restrictions on his license.
Okay.
Right? Secondly, with regard to the incident, the indication is he was trying to get his keys to then drive again, which would have been outside of his restrictions on his license. And there was at least the indication when there was a talk of intoxication that the defendant at that time may have been intoxicated.
I believe I said exactly that. He may have been intoxicated. Can I address that concern or not?
Go ahead.
Your Honor, if that's the concern is that he was driving when this happened, then an added condition of he can't be driving without a valid license.
No. My problem is with the whole story. Because why is he getting his keys to drive when he's not supposed to be driving? Is what I'm having difficulty even understanding the events as you're telling me they may have existed at that time.
She was intoxicated at Chelsea Lanes. He wanted to try to drive her home. She refused. She drove her cell phone. I haven't seen the alcohol test. I don't know whether or not she touched it or not. He followed her home to make sure she got there okay. The parties, he had generally, I believe, according to the report, it's spent most nights there. Then they got into an argument and he tried to leave, couldn't find his keys, and that's when the incident with the bed, the phone, and the glass breaking. I think, in my opinion, those sort of discrepancies are only, I guess, the absolute truth, I guess, would be relevant to the bond, but they decrease the likelihood of conviction when you have the alleged victim saying that her statements weren't entirely accurate and wishing to recant, and him saying he was looking out for her. When the argument got loud, he had asked her to keep it down so the children wouldn't hear them arguing because he was concerned about trauma they experienced from a prior abusive relationship. And telling her to calm down actually escalated the fight, and that's when the incident happened in the bedroom, which there's a disagreement about what that was. That, at the end of the day, resulted in the injuries that were sustained by the alleged victim to her wrists, our arms, and her head. I would clear up, since you gave me a chance, there were actually, I believe the people said there were 3 CAT scans, there were 4, there were 3 x-rays. I was able to do what they provided. But I think that the key issue in this bond is somebody who is a close friend, the alleged victim, has known Mr. Whitley for 20 years and said he's not violent. This has never happened. So, regardless of whether or not there's a conviction for purposes of bond, he does not pose.
Well, if I consider him a danger, Yes. I mean, what I've got here is I've got somebody that shouldn't be driving, who may have been intoxicated, who would have driven on 2 occasions when he's not supposed to be driving in violation of his restricted license, breaking the law. Then I have this confusion about the incident. I don't even know why she would have his keys if it now, as you're relating to me, that he drove and then followed her, which was not the indication that I got from listening to the arraignment. And then um, an altercation occurs that results in what I would consider significant injuries to the alleged victim in this case, to the point of a level of medical care that was required regarding that person, which I think would have been significant. And then from that, does she have to keep moving? And then, you know, it creates in this court's mind a level of potential danger that this individual poses, potentially to the victim as well as to the community. It certainly raises that level because he's not this law-abiding person that you say he is, because he's obviously driving. I mean, he's got those previous convictions, which led to the revocation of his license, which led to the restriction, and he's violating that twice that night, at least. So, I don't know. Sparoso, was there something else?
No, you're right.
Anything else, Mr. Bennett? Anything else, sir?
No, I just don't know. I get that he was driving when yes, he was violating his restriction. That doesn't warrant $180,000. I do think that some cash bond is appropriate at this point. I think it should be something that helps, especially in case that the likely sentence is probation.
Understood. And what I am additionally indicating is that in listening to what was the representations at the arraignment regarding what transpired, listening to what transpired that day, hearing what is today, it's unclear to me that that's what actually happened. Because that's not what's been said on the defense side about how this whole thing comes about. I then end up with an individual that is severely injured where they're at the hospital getting the treatment that they're getting. There's some indication that that's her fault. Maybe. But then, and that the defendant is trying to get away. I just find that version of events, it may indeed be true, but I find it, at least at this point, to be sort of remarkable that that would be it. The court, go ahead. What are you going to say?
I was just going to say that could solve my testimony.
Oh, I'm sure it certainly will, but I don't have that at this. It normally would during a bond hearing. I have to assess it based upon what I see, and I would say also, with all due respect to the magistrate of this court, that making a statement of giving a PR, but then indicating that the people might file an emergency bond motion. How she'd know that, I do not know. But that, from my perspective, leads the court to believe that it was in part of the court's funding, but also as a result of what the court is looking at in this case, would find that her decision to issue a PR bond was indeed an abuse of discretion in issuing that bond. The court will leave all of the conditions that she set in place. I will set the defendant's bond in the amount of $35,000 cash surety. Defendant remanded.
Thank you, Your Honor.
Bill 1. All right. Court stands in recess. Thank you.
All rise.
Least. What started as a routine bond hearing was about to become something far more intense. A defense attorney walked into the courtroom determined to challenge the court's handling of the case, believing the judge had treated one side unfairly. But within moments, the focus shifted away from the bond request and toward a heated courtroom confrontation that no one expected. What seemed like a simple hearing was quickly turning into a battle over credibility, respect, and the facts themselves. The judge had already addressed the attorney's earlier remarks, making it clear that questioning the court's integrity crossed a serious line. Instead of reacting impulsively, he gave the defense more time to prepare and present its arguments. When the hearing resumed, however, the discussion uncovered new inconsistencies that forced the judge to take a much closer look at the defendant's version of events. As both sides presented their arguments, the judge carefully examined the timeline, the conflicting statements, and the circumstances surrounding the incident. Rather than accepting explanations at face value, he repeatedly questioned whether the defense's story truly matched the evidence before the court. With every answer, the pressure inside the courtroom continued to build. The hearing had become about far more than a bond decision. It was now a test of credibility, accountability, and whether the defense could overcome the judge's growing doubts. What happened next would change the direction of the entire case and leave everyone in the courtroom waiting for the judge's next